Good afternoon, everyone. Our topic for today's training is procurement in action. We're going to talk about some different procurement scenarios. Just as a refresher, I want you to remember that the state thresholds for procurement are more restricted than the federal thresholds. The state doesn't require, but does strongly suggest obtaining 3 written quotes for procurements between $1,000 and $10,000. USDA requires that purchases under 10,000 you can use the micro purchase method, but you must spread the wealth amongst qualified suppliers. SFA has to seek at least 3 quotes for procurements between 10,000 and 30,000, and procurements of more than $30,000 must be formally procured. So let's talk a bit about using the micro purchase method. Over the years, we found that that SFAs really want to use the micro purchase method because, of course, that it's the easiest, but there have been numerous findings on use of the micro purchase method as a result because items are not being properly procured. So when you're going to use the micro purchase method, you need to ask yourself a few questions. First, will this type of product or service be needed again this year? Are there multiple vendors that can be used for the purchase? And is it logical to use more than one vendor? If your answer is that you will most likely need this product or service again this year, and you don't feel it is logical to use more than one vendor, then the micro purchase method is not the method that you should choose. Let's look at examples. The SFA knows that there will be a few times where their site manager will need to go to the store and purchase a few grocery items. There are 3 stores in town where the grocery items can be purchased. The SFA director instructs the site manager to alternate between grocery stores when purchasing miscellaneous grocery items, and thereby they're spreading the wealth. In this case, the micro purchase method is appropriate to use. Let's take a look at another example. The SFA again knows that there will be a few times where the site manager will need to go to the grocery store and purchase a few grocery items. But there is only one grocery store in town, and the next closest is 30 miles away. So it is definitely not logical to use more than one grocery store. If the SFA in this example has multiple schools and they're in different towns, another way to use the micro purchase method is to decide that the site manager in one town goes to one grocery store and the site manager in another town goes to another grocery store. Let's take this example. In one town, there's only a Piggly Wiggly. And so obviously the site manager has to go to Piggly Wiggly. But another school has 2 different grocery stores in town. They have a Piggly Wiggly and they also have a Safeway. So the SFA director instructs the site manager to use Safeway for the miscellaneous groceries. So between the 2 schools, they are considered sharing the wealth. Let's look at another scenario. The SFA is preparing the procurement plan for the coming school year. Equipment repairs are one of the categories that this SFA has under micro purchases because most purchases don't exceed the $10,000 threshold. The SFA knows that there will likely be multiple equipment repairs during the school year. And so the SFA has a decision to make before planning to use the micro purchase method. In this scenario, there are multiple vendors for repairs in the area, but there's only one that has shown to be really dependable. So knowing that there will be multiple repairs, it really isn't logical to utilize multiple companies. So in this case, the SFA would need to obtain quotes, or they could even do an RFP if they want to include evaluation factors such as dependability or references or any other factors. So the key point I want to make here is it's not just about the dollar amount. When you're deciding to use the micro purchase method or the small procurement method, you must consider things other than just the dollar amount. Just because the one-time purchase is under the $10,000 threshold, it does not mean it should be a micro purchase. In addition to the dollar value, what steps were taken to purchase the item? Oftentimes, I'll get a call from an SFA when they're trying to complete their procurement table for their administrative review. The SFA included all single purchases under $10,000 as a micro purchase, but sometimes they really are a small purchase. I see this scenario often. An SFA has purchased a washing machine for one of their schools. When deciding whether it should be a micro purchase or a small purchase, I asked the SFA director what steps they took before purchasing this washing machine. I have only had one SFA director tell me that they just went out and bought it without doing some research on the price. If you research the price and choose the lowest price, you have completed a small procurement, not a micro purchase. So I went to the internet and I searched for a specific washing machine. I obtained 3 prices. Lowe's was selling the washing machine for $899 before tax. It was out of stock, so I couldn't get the total price. Best Buy had the same washing machine for $880.45 with tax and free delivery. Then I went to Home Depot site and it was on sale. The total price, including the installation kit, which I forgot to include, with the delivery and the installation, was $628.99. So obviously, Home Depot was the best buy for the washing machine. I didn't go out and complete a paper procurement and reach out to a bunch of different companies. I just conducted a small purchase procurement because your web searches are proof that you got quotes on this piece of equipment. So let's look at some more scenarios. The school system has a very knowledgeable maintenance department that can repair most any refrigeration equipment. The SFA knows that refrigerator freezer parts will need to be purchased more than once during the school year. And there's only one company that sells parts in their town. So what do we do now? And the answer is, it depends. If you have a freezer full of food that you're going to lose if the freezer is not repaired quickly, the SFA should purchase the part, repair the equipment, and classify it as an emergency purchase and keep that documentation. But what if the refrigeration equipment is not in use and it's been broken for a while? Again, there's only one company that sells parts in town. In this scenario, the SFA does have time to get quotes. The SFA could get a quote from the only company in town. They also could get a quote from a company that is further away. They could also choose to go online and look at the cost of the part from two different companies and compare to the local company's price. Make sure to include the cost of shipping in the online cost. If the cost online is cheaper, the SFA could buy from the online company. But if the local company has the better price, the SFA would buy from that company. Just remember that any equipment acquisitions and any other capital expenses of $5,000 or more does need state agency approval before you incur the cost. The exception to this regulation is the equipment listed on the 2021 pre-approved equipment list, which is under Memo SFS 21-87. The equipment on this list has been approved by USDA and receives automatic approval for the purchase. So regardless of the procurement method used, whether it be a micro purchase, a small purchase, or a formal procurement, the SFA must obtain state agency approval if the expenditure will be $5,000 or more. When you're choosing the appropriate procurement methods you want to use, you also have to remember that if you are going to obtain multiple quotes throughout the year for the same items, and the total amount by the end of the year is going to exceed $30,000, the SFA must use the formal procurement method. If you decide to use the small procurement method and obtain quotes, remember that the SFA director is responsible for ensuring that the total does not exceed $30,000. I get a lot of questions about what to include in procurement documents. And that's the whole reason we have a procurement plan. Your procurement plan tells you all of the required information to include if you're going to do a small procurement. What if you want to do a small purchase procurement for equipment repairs? Many SFAs really prefer dealing with one company to repair equipment if at all possible. The first step would be to determine through your historical data if the SFA spends close to or over $30,000 per year on repairs of equipment. If not, using the small procurement method is appropriate. But if the SFA spends more than $30,000 or they're real close to the $30,000, they would need to utilize one of the formal procurement methods. If the small procurement method is appropriate, the SFA can obtain quotes from several different companies. Remember that when you obtain quotes, the SFA must choose the lowest bidder. Of course, with equipment repairs, you can't obtain a quote on the cost of parts because you don't know what parts will be needed. So you can do a small purchase procurement and get quotes on the repair of equipment. And the things that you would include in your quote would be things like the hourly labor rate. When does their hourly rate begin? Does it begin when the driver leaves the shop? Or does it begin when they arrive at the school? What is the company's percentage markup on the parts? Is there an additional charge for travel? What is the hourly labor rate for nights, weekends, and holidays? What is the company's regular working hours and days? what type of warranty do you want for your equipment? And what type of license and insurance is required? So you can, even though you don't know what equipment is needing to be repaired, you can actually get a small purchase quote for equipment repairs. And that way you can use that one vendor that does a particularly good job. You could also do an RFP and include service or references or any of those other things in your RFP. If your SFA believes that the total cost for the year is going to meet or exceed the $30,000 threshold, then a formal procurement has to be conducted. Commonly, food and supplies are procured by using an invitation for bid, also called an IFB, because cost is the main factor. But sometimes, though, SFAs have serious issues with companies not meeting the requirements of the contract. Now, of course, we're not talking about this year with all of the food and supply issues. This is just for normal times. We're definitely not in normal times. So the SFAs report difficulties with companies charging the correct bid price, delivering within a specified time, product substitutions, shortages, compliance with the Buy American provision. And I'm sure you all could tell me many more headaches you have working with some of the companies. All of these problems cost you time and resources when you or your managers have to check every single invoice to make sure the price charged is correct, or change the menu because the truck didn't come on time, or didn't send the product you ordered, or you receive substitution with items that are not in the contract, or they sent you Indonesian pears rather than US grown canned pears. An SFA can always make the decision to use an RFP, regardless of the dollar value of the procurement. Using an RFP allows you to score the companies on the quality of their service to you or to other SFAs. Price does always have to carry more weight than any other factor, but as you already know, the quality of service they provide is very important as well. I want to make sure that you understand some definitions that you're going to put into procurement documents. When you are writing a procurement document, be careful when using these words. If you want to make an item an absolute necessity, you should always use the word must instead of shall or will. Shall and will can be confused with predicting future actions. If it is a true requirement in order to bid, use the word must. Using the word should infers that it is an obligation, but it is not an absolute necessity. May indicates a discretion to act. Must not indicates that it is an absolute prohibition. When I was drafting an RFP for the Office of State Purchasing to approve, I was instructed to utilize must, shall, and will as little as possible, and to replace the word should with the word should. Sometimes stating must ties the SFA down to throwing out a bid when there is only a minor problem. Now, all these definitions that I have here came directly from the Federal Register, Drafting Legal Documents, Principles of Clear Writing. The link to this document is at the bottom of the slide and has some useful information about writing procurement documents. Must is not a must. Unfortunately, several SFAs have found this out the hard way. because they stated in their bid that the prospective vendor must provide specific documents in their bid, such as the independent price certificate or the lobbying certification form with their bid. Remember that stating must could cause you to throw out the lowest bid as being non-responsive because the document wasn't included. The SFA could have used the word should, which would give them the option of accepting the bid, but requiring the document to be submitted before the bid is awarded. One of our SFAs sent out an addendum to a bid, changing the dates of a contract. The addendum was sent out certified mail, return receipt requested. The SFA director received the return receipt from 3 of the 4 vendors. She did not receive the return receipt from one vendor, and so there's no way to determine whether the addendum was received by the vendor. As a result, the SFA had to accept the proposal. So a lesson to be learned here is to make sure that you receive the return receipt from all vendors. But look at the statement on this slide. It states this addendum should be attached to the front of the proposal form and returned as part of the official proposal. Note that the statement says should and not must. And should infers an obligation, but is not absolutely necessary. The vendor, in this case, that didn't receive the addendum and attach it to the front of the proposal was the low bidder by over $80,000. Because the SFA director used the word should instead of must, the SFA was able to award the bid to the low bidder and obtain a signed copy of the addendum before the award was made. That's definitely a lesson learned. Another SFA sent out a bid that was to be awarded item by item. The bid stated that all frozen items must be delivered to the schools. But the SFA director received a bid from a supplier that bid only one item, pizza. The vendor gave the SFA a far better price, but stated that he could only ship to the warehouse. The SFA director was willing to accept the pizza at the warehouse and distribute to the schools herself because the price was that good. However, there was a glitch. The bid stated that all frozen items must be delivered to the schools. If she had accepted this bid, she could be subject to a bid protest. But if the bid had stated that the vendor must be willing and able to deliver all frozen items to the schools, unless otherwise directed by the SFA director, the bid could have been accepted. Using this statement, the SFA director would have the discretion to allow it to be delivered to the warehouse. The bid could have also read that the vendor will deliver frozen items to the school or the warehouse as directed by the SFA director. Well, Louisiana law doesn't require SFAs to advertise, receive bids, or engage in competitive negotiations for professional contracts. However, USDA does require procurement of professional services. Since the federal requirements are more restrictive than the state requirements, we must follow the federal requirements. So let's move on to formal procurement. Many SFA directors are afraid of writing formal procurements. All of the requirements for a formal procurement are included in the sample procurement plan. The procurement plan includes the requirements of an IFB and an RFP. It also has some suggested language that you can use, such as disqualifying a vendor, terms and termination, that type of thing. There are also many IFBs and RFPs posted on the internet that can be used to assist in writing a formal procurement document. Review some of these for ideas of what is needed in the document. I've also created a sample invitation for bid that includes all of the requirements. It is a Word document, and the SFA can add additional requirements if needed. Let's talk a little bit about advertisements. I have seen some very wordy advertisements that SFAs have used. Advertising, as you know, is very expensive, so the SFA should strive to shorten their advertisements if possible. The requirements of an advertisement include providing a general description of the items to be purchased, the deadline for submitting questions, and when the vendors will receive written responses, date of the pre-bid meeting, and if attendance is required to award the bid, if a pre-bid meeting is going to happen, and deadline for submitting proposals, the address of where the complete specifications can be obtained, and of course, the short version of the non-discrimination statement. The entire non-discrimination statement is not needed. Of course, the advertisement has to appear in a regional news source at least twice, meaning on 2 different days. Revised statute 38.2212.1 states that public schools must provide vendors the option to submit bids for public contracts through a uniform and secure electronic interactive system. SFAs have stated that putting their bid on an electronic bid platform is expensive, but there are some bid sites where the cost is charged to the vendor that is submitting the bid rather than the SFA. Also remember that sending bid documents through email is not considered a uniform and secure electronic interactive system. And if a prospective vendor requests to submit their proposal electronically, the SFA cannot also request a paper proposal. Let's talk about affirmative action, because even though the affirmative action statements are required in each bid, it's not just a matter of including the required provision in your formal procurements. The sponsor and the vendor must take all necessary affirmative steps as outlined in 2 CFR 200.321 to make sure that minority businesses, women's businesses, and labor surplus area firms are used whenever possible. The required affirmative action steps including making sure that you have small and minority businesses and women's business enterprises on solicitation lists, assuring that small and minority businesses and women's business enterprises are solicited whenever there are potential sources, dividing total requirements when economically feasible into smaller tasks or quantities to permit maximum participation by small and minority businesses, establishing delivery schedules where the requirement permits, which encourages participation by small minority businesses, using the services and assistance as appropriate of such organizations as the SBA and the Minority Business Development Agency of the Department of Commerce. And the last requirement is requiring the prime contractor, if subcontractors are going to be used, to take the same affirmative action steps. When the state agency reviewer asks for proof that you follow these required steps. How will you respond? Do you maintain a list of qualified small, minority, and women-owned businesses? Do you know where to look for qualified vendors? The links to the SBA list and the Hudson list are included in the procurement plan. These are two sources you can review when looking for small, minority, and women-owned businesses. If you are using an all or nothing bid, you must extend the price each vendor proposes based on your estimated quantity. If you award a bid based on the item price, you may not actually be awarding the bid to the vendor with the lowest overall price. Look at the example on this slide. If the award is based on the item price, then vendor number 3 would win the bid because the total item price is $32.85 for all of the items. But vendor 3 does not have the lowest overall price. In fact, their total price is higher than either of the other 2 vendors. They are $4,064.11 higher than vendor number 1. Vendor number 1 should be awarded the bid. And we have had an SFA that had to retract a bid award because they based the award on the lowest item price rather than the overall price. One of our milk vendors was threatening a bid protest because they were actually the low bidder based on the total dollars. Using equal or pre-approved equal. The question is always, should I use the term equal or pre-approved equal? If I state in my bid specifications that I want scrubbing cleaner number 1 or an equal, then looking at the ingredients in these products, they're not the same thing. There is no exact equal because each manufacturer probably has a slightly different formula. So stating equal would be considered restricting competition. Or one distributor could argue that my product does an equal job to the product you are requesting, so it should be considered an equal. But if I use the term pre-approved equal and provide the prospective vendors with a procedure to follow to get an equal product pre-approved, then the SFA determines what is considered an equal. It does take more time, but you're more likely to get an acceptable product. One of our SFA directors used the term pre-approved equal in her bid and had some of the employees test product 2 against product 1 that was provided by a distributor to see if they felt like it was equal to the brand of product on the bid. The employees were not at all happy with the product and stated that it did not do an equal job. As a result, the SFA director didn't allow it as an equal, and all distributors had to bid on product number 1. And the icing on the cake was that her employees felt like their opinions were valued in the decision-making product. So what were these products? Comet and Ajax. Now, I may prefer one over the other, but I need to have a legitimate way of determining if it is an equal. Another SFA director stated a brand name in her bid and used the term or pre-approved equal. She gave prospective vendors a deadline to submit products to be considered. One prospective vendor wanted to submit the proposed equal product after the deadline she had given in the RFP. If this happens, the director should not consider the product. What might happen if the director had allowed the product to be submitted after the deadline? Other vendors could have protested the award of the product because the vendor submitted it after the deadline. Remember that all documents that are part of your bid process are considered public information. I think we could all be found guilty of having a preference with brands of equipment because we all know the main companies in the restaurant equipment world. I know that Vulcan, Hobart, and Blodgett are considered good brands of ovens. Many directors don't feel like they have the expertise to determine what would be considered an equal when procuring items like software or equipment. So we need to seek information and guidance from people that do have the knowledge. Your maintenance department or your IT department can be invaluable sources for assisting you in determining if the products proposed are equal. Searching the products on the internet may also be helpful. Sometimes you can even find comparison of equipments online. Again, using the term pre-approved equal allows you the flexibility to do your research and possibly limit the number of different brands proposed. Make sure that you give yourself ample time between letting the bid and the bid opening date to complete your research. Just remember that the distributor or broker that develops or drafts specifications, requirements, statements of work, IFBs, or RFPs must be excluded from competing on the procurement. This regulation can be found at 2 CFR 200.319. I get asked this question many times by SFA directors about the Buy American provision and whether it applies to equipment. And the answer is no. The Buy American requirement applies only to U.S. grown and processed agricultural products. 2 CFR 200.322 does allow an SFA procuring equipment under a federal reward. It does say that the SFA should provide a preference for the purchase of goods and products made in America. But of course, USDA also requires that competition for the best price. So it is a balancing act. Out of curiosity, I researched where some of the ovens were manufactured. Hobart, their manufacturing headquarters is in Ohio, but they have multiple manufacturing plants in the US and other countries. Blodgett ovens are made in the US, and Vulcan is also a US company. Of course, ovens have many parts, and I was not able to find out if all of the parts were made in the US. What about cooperative bidding, cooperative pricing? Memo SFS 17-07 is a Q&A on purchasing goods and services using cooperative agreements, agents, and third-party services. In that memo, it states that when competitive procurement methods are conducted by the program operator, GPO price list can be one source of prices when using small purchase procedures, sealed bids, or competitive proposals. This memo means that when an SFA is conducting either a small purchase or a formal procurement, they can compare the prices received by vendors to the cooperative pricing and can use the cooperative pricing if their price is cheaper. If you plan to compare the prices received by vendors to a cooperative's pricing, make sure you state it in your bid. This is different than an SFA just saying, I'm going to use a cooperative pricing without conducting proper procurement. That is not allowable. And I strongly encourage putting statements in your bids that you're going to compare to either cooperative pricing or state bid prices, because in some small areas, vendors know that they're pretty much the only vendor. And so using either the cooperative pricing or the state pricing can actually help to increase the competition and hopefully make the local vendor a little cheaper. Sometimes you have to use third-party delivery. So make sure that you have everything in your contract. Make sure that the contract includes all specifications on delivery. And do you require the items to be delivered inside your building? And specify where inside the building. Otherwise, you may be left with a pallet of frozen pizza sitting on your curb with no way to get the pallet inside your freezer. Third-party vendors often have additional fees for delivering inside. If one vendor wants to ship via a third-party delivery service, but the delivery service is going to charge more for delivering inside or to the freezer, they may not be the lowest bidder. Contracting for additional goods and services. When you are contracting for goods, you may include a provision, and it's also in the procurement plan. You can include the provision in your original solicitation that states that you reserve the right to add goods to an existing contract if the following conditions are met. The SFA must state in the original solicitation that the total value of all additional goods and quantities of listed goods may not exceed the limit specified in the solicitation and contract. The SFA can use a percentage of the estimated total value of the contract to determine the value of goods and services of goods that may be added. USDA recommends limiting additional costs to 5 to 10% of the estimated value of the contract. The total estimated value of the contract has to be included in the solicitation to include this provision. If the contract allows a renewal option and the renewal option is approved as established in the original contract, then upon renewal, any goods that you added to the contract in the first year would be included in the contract amendment for the second year. If a contract is renewed, there then is a new basis for the contract value that includes the actual expenditures of the previous bid period, plus the value of the additional items must be included in the contract renewal as well. Your actual expenses may fall below the initial estimated value of the contract and could result in a lower contract value in subsequent contract periods. Termination for cause and convenience are required provisions in all formal procurements. On many occasions, when I review procurement documents, the SFA includes the language on, on this slide rather than including the conditions that would cause the SFA to terminate the contract. Sample language is included in the procurement plan. However, the SFA is free to utilize their own language for both termination for cause and for convenience. The language in the procurement plan for termination for convenience reserves the right to terminate the contract at any time for any reason by giving a certain number of days notice to the contractor. The number of days notice is up to the SFA. It also states that if the contract termination is not the fault of the vendor, they will be paid for all items received or any work completed as of the date of the termination. The language in the procurement plan for termination for cause states that when a contractor is in default, the SFA can purchase all products on the open market and charge the vendor with the excess cost. It also states that until the assessed charges are paid, no bid from the defaulting contractor will be considered. And it states that the SFA reserves the right to terminate the contract for any reason by providing the contractor with a certain number of days notice. There's also a list of actions that can cause an SFA to terminate a contract. Some of the examples are failure to deliver within the time frame specified in the contract, not meeting quantity requirements, failure to meet the specifications in the contract, and there's several others. Having this language in your contract protects your SFA. If you need to disqualify a vendor from bidding, please make sure that you follow the procedures in the procurement plan. The vendor must be notified of the disqualification in writing and be provided the opportunity for a hearing. If you disqualify a vendor for a specified period of time, after the time has elapsed, the vendor must be allowed to submit a bid. But there are no requirements that you allow a vendor to bid if a bid time or a period of time is not specified. What about tie bids? Several SFA directors have had an issue with tie bids. This typically only happens when the SFA is awarding an item by item bid. The SFA could or should include what steps they will use to award a tie bid in their proposal. The SFA could split the award between the tie bidders, or they can even do just a coin toss to determine who will be awarded an item. Of course, if the SFA uses an all or nothing bid, there typically are no tie bids. Oftentimes, particularly with smaller SFAs, only one vendor responds to a bid. And the SFA never wants to be in a situation where they have to accept the prices of the only responding vendor. The SFA needs to give themselves some options in their procurement document. You can include a statement that bids will be compared to the state contract, or like we were talking about earlier, a purchasing cooperative, to determine if their prices are cheaper. Procurements that are sent to at least 3 prospective vendors, but only receive 1 response, do not have to seek state agency approval to award the procurement. SFA directors are required to seek state agency approval when they are conducting a non-competitive procurement, such as when an item is available only from a single source. It's highly recommended that a vendor statement of no bid be included in the solicitation. The SFA should request that vendors that choose not to bid complete and return the form to the SFA. The document states that due to the limited number of vendors in our area, we are encouraged to seek out and request a statement of no bid in order to maintain compliance with federal state procurement requirements whenever there is limited competitive bidding. If your company does not intend to submit a bid, your submission of the statement of no bid will help us meet the justification requirements for a contract award. USDA strongly encourages SFAs to review their procurement process when they receive only 1 bid to determine if there is anything else the SFA can do to encourage competition. Could you be sending a bid to a company that doesn't offer the product? Is the company unable to meet the specifications or procurement requirements? And if so, can the SFA make changes to the specifications to encourage competition? A big deterrent is that many companies don't want to deliver to rural areas. Could the SFA partner with a nearby SFA in procuring to help it make worthwhile for the company to come to your SFA? But ask the vendors what you can do differently that would encourage them to submit a bid for your business. Remember that you always need to have an independent price certificate included with any formal bid, and it is signed by both the offerer and the SFA, and the SFA must maintain it on file. It certifies that the prices in the offer have been arrived at independently by the offerer, that the price quoted in the offer have not knowingly been disclosed to any other offerer prior to the opening of the bid, and it certifies that no attempt has been made to induce any person or firm to submit or not submit an offer for the purpose of restricting competition. Remember the debarment and suspension. The SFA cannot award a contract to any company that is listed on the government-wide exclusions in the System for Award Management, commonly known as SAM. Each vendor must complete the suspension and debarment certificate before the contract can be awarded, and you can find a blank copy of the suspension and debarment certificate and all of the information in the procurement plan. This is a copy of what it looks like in SAM for a company that is active in SAM. The System for Award Management, or SAM, is an official website of the U.S. government. They made it much more complicated to get in. You actually have to register now and do all kinds of things, jump through hoops to get onto the SAM website. But any business that wants to do business with the federal government has to have a DUNS number, and they have to be registered and remain active in SAM. The business must update their entity registration on a yearly basis. A business can be suspended from doing business with the federal government if they have committed fraud, embezzlement, theft, forgery, bribery, tax evasion, violation of antitrust statutes, willful or a history of failure to perform, violation of the Drug-Free Workplace Act, delinquent federal taxes of more than $3,000, and a number of other reasons. The SFA should obtain the prospective vendor's DUNS number and check the SAM.gov website to ensure the vendor is active before awarding a contract. You can look the vendor up by name, but like I said, they don't make it easy. But this screenshot shows that Capital City Produce is active in SAM. And I have to tell you that I searched several of our local vendors that are used by many of our SFAs before I found one that was actually active. Remember that contracting and paying a vendor that is not active in SAM is unallowable, and USDA could deem those payments to the vendor as unallowable. A vendor can choose on the SAM website to list their business as private, where the SFA can't view whether the vendor is active or inactive. The SFA does not have to accept the bid if a vendor will not provide them access to view their SAM status online. Vendors have to also provide the SFA with the completed signed lobbying certification if the bid award will exceed $100,000. The vendor is certifying that it has not and will not use federally appropriated funds to pay any person or organization for influencing or attempting to influence any officer or employee of any agency, a member of Congress, officer, employee of Congress, or an employee of a member of Congress in connection with obtaining any federal contract, grant, or other award. The vendor must also disclose any lobbying with non-federal funds that takes place in connection with obtaining any federal award. One of the most common findings on procurement reviews is that the code of conduct doesn't include all of the required elements. The requirement elements are that no employee, officer, or agent of the SFA can participate in the selection or award or administration of a contract supported by program funds if a conflict of interest, real or apparent, would be involved. Employers, officers, or agents cannot solicit nor accept gratuities, favors, or anything of monetary value from contractors, potential contractors, or parties to sub-agreements. This code of conduct has to be signed by all employees involved in the procurement process, and it must include disciplinary action for violations. There is no reason to reinvent the wheel. There is a blank code of conduct form that is included in the sample procurement plan to be used by SFAs. There have been numerous findings on procurement reviews because SFAs have used their own code of conduct document, which doesn't necessarily include all the USDA requirements. Now, if all of the participants remain the same, you do not have to complete new forms every year. You can simply upload the signed forms to the CMP website. I know that was a bit long, but do we have any questions? Should we start asking for their DUNS number as part of the information requested on the contract page? My answer would be yes, that you should ask for their DUNS number, and make sure you check their DUNS number in SAM. And if you have trouble getting into the SAM website, give me a call, because like I said, it really is an act of Congress to get in there and get the active information. Have any other questions? Well, as always, we appreciate you joining us for our trainings. If you have any questions, please feel free to contact us. I think no one just came in. If a respondent to an RFP refuses to provide the independent price determination form, should they be considered non-responsive? Absolutely. You can't, it is a requirement. And I've checked this just recently with USDA because I wasn't finding it in the regulations. And I just double checked with USDA just a few months ago, and they do still require the independent price determination. When will we get a copy of this presentation? As soon as Pennington uploads it. Now I can, if you need it for something in particular, I usually can't email the recorded presentation because it gets so large, but if you need a copy of the PowerPoint presentation, I'm certainly glad to email it to you. But look to the Pennington website for a copy of the training. It should be uploaded. Okay, so let's see if we have any more questions, and I wish you all a very good week.